Hey everybody, welcome back. Today we have breaking news out of Colorado, specifically regarding qualified immunity, the use of carotid pressure or chokeholds, body cam footage, how much information a prosecutor must release, and when body cam footage must be released. Let's jump into it. Now, the first thing that I personally want to go over is qualified immunity, even though it's not the first thing that the bill addresses, but Senate Bill 217 in Colorado was just passed like 2 days ago. Basically makes it so that under the law, officers can be sued in their individual capacities for up to $25,000. Earlier renditions of this bill would have made it so that you could actually sue the officer for up to $100,000, but that has been dropped down to $25,000. There's also a provision within the bill that says if the officer cannot pay that $25,000, then the municipality that employs them or their insurance carrier will have to pay that bill. This is a new trend. We're the first state to do it, and hopefully we see this sweep the nation and qualified immunity can finally be abolished. The next portion of the bill that I want to cover is regarding body cameras. The new law requires that police officers activate cameras, either worn on their body or mounted on the dash of their patrol cars. Their use is required during any interaction with the public, whether consensual or non-consensual. The only time that body cams can be turned off is when there's a long break in an incident or when recording personal information such as gathering a phone number or taking down information from a driver's license. Undercover officers are not required to wear body cams. Cops who fail to activate or tamper with their body cam during an incident can face civil or criminal charges. Anytime there's alleged misconduct from an officer, the video from that incident must be released unedited within 45 days of the incident. The bill also has new requirements on how officers can respond to peaceful demonstrations. The new law prohibits officers from using tear gas on protesters without warning and from firing less lethal projectiles indiscriminately at demonstrators' heads, pelvises, or backs. We've been seeing a lot of that in the recent protests, people being shot in the face with rubber bullets, beanbags, etc. Officers are also no longer able to use carotid and chokeholds. And for those of you that don't know, the carotid artery is the major artery that supplies blood to the brain. And why this portion of the bill wasn't already law, it totally defeats me, but officers must now intervene if a colleague is acting inappropriately. Law enforcement officers under Senate Bill 217 must intervene if a fellow officer is using inappropriate force against a member of the public. Peace officers who stand by as a colleague uses excessive force can have their certification revoked. They're talking about the post-certification, the Peace Officer Standards and Training certification. The board shall not under any circumstances reinstate the peace officer certification unless the officer is exonerated by a court. Really still don't understand why that's just becoming law. This is why you hear that saying, the blue backs the blue, but the blue don't back you. Also in the bill are better safeguards to track officers who are fired from one police department and the sheriff's offices to prevent them from moving agency to agency, because we've been seeing a lot of that. Somebody gets fired and all they do is apply down the street and they get rehired. Also, starting in July of 2023, the Senate Bill 217 requires law enforcement agencies to collect and report to the state a vast amount of data. That includes racial data on officers' encounters with the public, where the interaction took place, and the circumstances, including the suspect crime that occurred that led up to the situation. They'll also have to report whether or not they unholstered their weapon, whether they fired it or not, and I believe that also applies to tasers. And this is another big portion of the bill, and this was inspired by the shooting of Devon Bailey. That happened in Colorado Springs just a couple of years ago. But basically, this is the fleeing felon law. So no longer can a cop shoot a fleeing felon in the back. Now, in the case of Devon Bailey, they had just jumped a kid and robbed him and was stopped by the police. And in the middle of this interaction with the law enforcement officers, Devon Bailey took off running, and it appeared as though he was reaching for his waistband. Not sure if he was holding up his pants or reaching for the gun that was tucked down there, but as he was running away, was shot in the back multiple times and died on scene. This law now prevents law enforcement officers from shooting people in the back. In the case of Devon Bailey, those officers' actions were deemed justified, but with the new laws, they would be deemed unjustified. Senate Bill 217 changes that standard to require that officers face an imminent threat before they use deadly force. Running away is not an imminent threat. They're also prohibited from using deadly physical force to apprehend a person who is suspected only of a minor or non-violent offense. Law enforcement must also try to use non-violent tactics before resorting to using deadly force. Law enforcement officers must now legally identify themselves as such and give clear warning that deadly force may be used. Officers would obviously be exempt from the requirement if the warnings would place themselves or others at risk of death or injury. Also, regarding the fleeing felon law enforcement will be allowed to use deadly force against a suspected fleeing felon only if there is an imminent threat of the person using a weapon as a part of their escape, but they cannot shoot into crowds, and the person must be a threat to their lives or other people's lives.
Capitol, where the governor signed a sweeping police reform bill into law, making Colorado one of the first states in the country to do so. A Black Lives Matter demonstration in Denver taking on a celebratory tone, though it was a bittersweet victory for some. KRDO News Channel 13's Crystal Story has been following the day's developments from Denver.
Lawmakers say this new law is the first of its kind in the United States. It creates a database of police officers who have use of force violations to prevent them from getting hired elsewhere. But Devon Bailey's family, who was here today, say this law is coming too late for their son. On a day of victory,
we passed Senate Bill 217! The first in the nation!
Celebrating the new law titled Enhanced Law Enforcement Integrity is bittersweet.
The governor signed this bill that came a little too late, a lot too late. I'm hurt, I'm upset, I don't know how to feel.
Bailey's 19-year-old son, Devon, was killed last August after he was shot while running away from Colorado Springs police.
Hands up! Hands up!
Both officers' actions were ruled as justified. Bailey believes a new change in the law that bans officers from using deadly force on a fleeing felon could have changed his son's outcome.
For Colorado to be the first in the nation to actually sign something to justify everything that they did to my son, to these families, that was justified, is now a law.
The bill was sponsored in part by Senate President Leroy Garcia from Pueblo, who believes this law will help agencies have the best officers.
Many of them are great officers. They have good integrity. They're in the business for the right reasons, to serve and protect. Those officers who aren't, this bill is going to apply to them. We want to ensure that we have exceptional officers out there working.
But he admits this is just the beginning. While protests across Colorado start to slow down, he hopes the community keeps the momentum for change. This law goes into effect immediately, but departments who still need to equip every officer with a body camera have 3 years to comply. At the state capitol, Crystal Story, KRDO News Channel 13.
This bill that I'm about to sign bans chokeholds. It creates new standards for the use of force, including not using deadly force when a person is only suspected of a minor or nonviolent offense. It includes requiring all peace officers who interact with the public wear body cameras. Many do already, but this will make sure that going forward that will be phased in across all law enforcement activities in our state. Allowing individuals, really creating a new duty for police officers to intervene if they see a fellow officer engaging in an inappropriate use of force, instead of just standing by and watching. Requiring peace officers to have a legal basis for making contact with individuals, and after making that contact, reporting the perceived demographic data, and requiring new data reporting on the use of force. This is a meaningful, substantial reform bill.
Senate Bill 217 brings about greater accountability, transparency, and increased integrity to law enforcement. The policies in Senate Bill 217 are not new. Matter of fact, they're the result of decades of conversations and sadly also decades of police departments that turn a blind eye to unacceptable behavior. We share in the Colorado General Assembly the responsibility to build trust between communities and law enforcement. And I'm proud of the work that we've been able to accomplish together, accomplishing the change that the people of Colorado demand.
That's it for today, guys. Thanks for joining. If you want to read the entire article that I just read you, I'll leave a link down below. It's from the Colorado Sun, and I will also leave a link to the new bill, Senate Bill 217. That will also be down in the description. If you're new here, consider a subscription. If not, like, comment, and share, and I will see you guys in the next video.